Hello, my name is Rich Freedman, and I'm an associate professor and head of the Legal Studies Department in the LeBeau College of Business. And today it's my pleasure to come and speak to you about something that we all like to talk about, death. Now, I know that people don't really like to talk about death, and I know that as an attorney, because it's very difficult for me to get people to come in and talk about planning their estate and what to do with it after they're gone. And so today, it's my pleasure to bring to you my top 10 reasons why you don't want to have a will, so that you don't have to come and talk to a lawyer. And I do this in deference to David Letterman. Reason number 10, I want my children or other relatives to fight over who will handle my estate. Or, alternatively, I would like to have a friend of the judge appointed to take care of everything I worked for and to make sure my family receives that to which they are entitled. What does that mean? Simply this. If you don't have a will and you don't designate someone to handle the affairs of your estate, it becomes a crapshoot. Now, there are certain pecking orders that are allowed, spouse and then children, but if you don't have a spouse and you have multiple children, they may all fight over who's going to handle your estate. So the best thing to do is to have a will and name an executor. Reason number 9. I'm glad to have my second cousin, twice removed, whom I never liked, to receive a portion of my estate. Many people think that if you die without a will, everything goes to the state. That's not entirely true. In fact, the law sets up a pecking order in which certain people get a share of your estate. If you have no spouse and no children or parents, it then goes up to uncles, aunts, and cousins, brothers and sisters. And you cannot control who's going to be able to get any portion of your estate. So if there's someone you really don't like, and you really don't want them to get a share of your estate, then you should make sure that you have in your will how you want your estate to be distributed beyond your immediate family. Number 8, I'm happy to give my entire estate to the state in which I reside to fill potholes instead of giving it to a deserving charity. The one time that an estate does go to the state is when you have no discernible heirs, and that goes down through parents, siblings, uncles, aunts, cousins, etc. And there have been situations like that in the past where someone has passed away without having any discernible heir. In that case, the state gets the money, and they may use it for potholes, but they'll certainly use it for something other than what you intended. My recommendation always is that when someone does not have any heirs, that they set up their will in a way that it will go to a charity so that the money can be put to good use. Number 7, I'm proud to be an American and support my country and state, and I'm happy to pay a portion of my estate, maybe up to 35% or more, when I die. Because while I loved paying taxes while I was alive, I'll be even happier to pay taxes when I'm dead. Not many people are aware of the fact that there is an estate tax and an inheritance taxes in various states. And there are ways to plan around those taxes and to minimize the impact of the taxes. But it's sort of like the government's last tag. If you remember as a child when you were playing and you would hit your friend and he would hit you and you were always trying to get the last tag, the death tax is the government's last tag. They get you and you don't tag back. So if you don't set up a will which is structured in a way to help you avoid paying as few, or to help you pay as little tax as possible, you will pay the maximum tax. Number 6. It's okay for my family and my spouse's family to fight over the care of my children after I die. And if they can't decide, I'm okay with the court appointing a stranger to care for my children. One of the things that people need to have a will for, if nothing else, is to designate who is going to be the caretaker for their child, the guardian. Under the law, the guardianship first passes to the surviving spouse. Now, this could be problematic if the spouse hasn't seen the parent hasn't seen the child in some time, but still they have the first right. After that, it goes first to the family, and then if they can't decide and the court gets frustrated with the family, it will go to a stranger that the court appoints. The best way to avoid that and to make sure that your children are cared for by someone that you really want them to be cared for by, you should just simply put in a will that you want to have them take care of your children. Simplest way to avoid having a stranger get involved. Number 5, my spouse will be thrilled to have to go to court on a regular basis to get monies from my estate to pay for the support of my children until each of them is 18 years of age, and to file a report annually with the court showing how every dime was spent. Under the law, if a minor is to receive a portion of your estate, then that money has to be deposited into the court. And the guardian for that child, usually the spouse, has to go to the court and request that the court release the monies to the spouse for the benefit of the child. Additionally, the spouse will then have to file an annual report with the court showing how every single dime was spent, because the court is overseeing it. The other problem with this is that the court will invest the money in areas that are very, very, very conservative, producing very, very little return, and that may not be what you want to do. So in order to avoid this problem, you have to set up in a will a trust for the benefit of your children, giving the trustee, either the spouse or someone else, instructions as to where that money is to be invested, how that money is to be spent. And in that case, the trustee does not have to go to the court and ask the court's permission to get every dime for the benefit of the child. They may still have to file an annual report, but they are then controlling all of the monies, and it's much easier for them to file an annual report. Number 4, I love my children so much that I want them to have all or a portion of my estate the day they turn 18 years of age. Under the law, a child is emancipated at age 18 and is entitled to inherit from a parent. In that case, the child is going to get everything. I had a case once where a child inherited $200,000 at age 18, and at age 19 had a truck. Nothing else but a truck. Had a great year, but only had a truck left. If you set up a trust, as I mentioned earlier, for the benefit of the child, that money can be used for the college, for support, health, for a truck, for a house, for a business, for any other need that the child may have up to a certain age. But you are the ones that are directing how that money is to be spent. It's not all going to the child. Number 3, even though my spouse and I worked hard for years to accumulate our wealth, he or she will be thrilled to share a portion of my estate with my parents who thought I could have done better in selecting a spouse. I don't think anyone realizes that when someone dies without children, that the entire estate does not go to a spouse completely. Under the law in most states, a portion of that estate will go to the parents of the deceased. And so if you don't want your wife to have to share, or your husband to have to share a portion of their estate with your parents whom he or she doesn't like, or vice versa, then you need to have a will to set forth the provisions that everything will go to your spouse. Number 2, after my death, I'm happy to give a share of my estate to a child of mine from a previous marriage or assignation, whom I haven't seen in 20 years, but who likes to check the obituaries. This is not an isolated case. Children from prior marriages have a claim against the estate of a deceased person, even though they may not have seen that parent for 20 years. And a child has the right to share with a spouse, just like the parent of the deceased does, when it comes to getting a share of the estate. So if you have children from a prior marriage or from a prior occurrence that wasn't a marriage, then what you want to make sure of is that your estate is set up in such a way that everything goes to whom you want it to go to. You can, under the law, disinherit a child. You cannot, under the law, disinherit a spouse. And finally, the number 1 reason, after my death, if my spouse remarries, I'm comfortable with the new spouse getting at least 30% of everything my spouse and I worked for, even to the exclusion of my children. You cannot disinherit a spouse. I'm repeating what I just said. And so therefore, a spouse under most laws has a right to take what's called an elective share of an estate. So if you're concerned about your assets passing to your wife and then going to a new spouse, you need to create some sort of a trust vehicle in your will to make sure that that money doesn't pass directly to the spouse and thus not directly to the new spouse. Now, I realize that this presentation was a little bit tongue-in-cheek, and it was done so for a reason. People avoid coming and talking about doing a will. as a species, we humans are cursed with the knowledge that we are mortal, and therefore nobody wants to address this. I've had people come to me who have been in their 80s getting their first will. You should not wait that long. If you intend to make sure that your estate goes to where you want it to go, then that top 10 list of reasons why you don't need a will should give you reason to get a will.